My name is Ranjan Agarwal and I'm a partner in the litigation department in the Toronto office of Bennett Jones. I think we pride ourselves on being trial lawyers first and foremost, but we obviously act for clients in front of tribunals, regulatory bodies, and if necessary on appeal. I think one of the real strengths of the Bennett Jones litigation department is that we don't specialize or focus on a particular type of dispute. So if you walk around the office on any given day, you're going to find people who are doing securities work, class actions work, employment disputes. They may be acting in small claims court. They may be in the Supreme Court of Canada. So the subject matter of the dispute varies. The type of court or the type of proceeding we are in varies. Really the full gamut of what the litigation bar does. I think for most clients in today's business environment, litigation is an unpleasant and hopefully unnecessary outcome to a business dispute. I think the key for our litigators is to use the tools of litigation, what a trial might look like, what the evidence is going to be, what the costs are going to be, in order to give advice to the client at the front end, and also to try to persuade the other side why a non-litigious resolution might be the best way. I think there are really three things that differentiate us. The first is culturally, we think of ourselves as entrepreneurs. And I think as a result, what that means is we often operate, even though we're in a big firm, like small business people, and we understand the risks and rewards that come with being a small business person. So when we're advising a client, we really take on board the challenges that they're facing, and as a result we can really empathize and figure out a strategy that will meet those demands. The second thing is I think we're eminently practical. I think a lot of my colleagues here, and I think the way in which we train junior lawyers, the way I was trained, was to be reasonable. And so the result is that we don't take positions that are overly aggressive just on principle. We see a real role as a litigator or as counsel in advising our client as to what the reasonable or practical outcome is. But at the same time, this is the third reason, we can be aggressive and ultimately fight if we need to. I use the line, or I paraphrase the quote from Churchill, which obviously was in a different context, but we'll fight if necessary, but not fight unnecessarily. And I think that's important. I think, in the life cycle of a mandate, the client's view on it can change dramatically. Today, if you've been hard done by, someone's stolen your confidential information, or someone is suing you, and you think there's a real problem with that, you may be prepared to fight quite aggressively. But as the file changes, as time goes on, as cooler heads prevail, as people move on, at that point it may be that a resolution is necessary. And I think we're really nimble at finding the right approach at the right time.